closeness of the vote, I think should be looked into. The first has to do with, were the new homeowners, after the petition was submitted, were those new owners in the roughly 3.5 months between the time the petition was submitted and the time the vote closed on July 19th, were those new owners notified of their right to vote? Now, at some point you reach a practical limit where they can't be notified because there's no time to get something letter out and letter back. But the question I'm having is, were those owners notified? And the other question relative to that is, there were a number of owners who had multiple properties that were only allowed one vote, and those votes were eliminated. But there were some owners who had multiple properties in various names. And my question is, were those property owners notified of their right to have multiple votes based on the different titling of the properties that they had? I'm aware of one case where that happened, and that was a person who happened to be in this meeting, saw that his 3 votes had been cast out, and wrote a letter outlining why they should be included, and they were included. Okay. So we're talking about 469.25 votes are needed to defeat this. You're saying 470, rounding up rather than rounding down. But in any case, 10 or 11 votes are needed, and it's so close that to not have all the owners who are rightfully allowed to vote, as well as those owners who can cast a no vote because they have multiple properties properly titled and allowed to do so, I think overlooks that aspect of the data. And so that's one thing I'd like you to consider. If this were 200 votes no, then this would need to be a discussion. There can't be that many that make a difference. If it were 600 votes no, it still wouldn't be a question, right? But now we're at this margin where it could matter. And so I would request that it be looked into. And then the final thing is the protection of the homeowners. And I firmly believe that districts are needed. I see nothing in the law that disallows districts. The law is silent on having districts. So I don't see any reason why we can't have it. And I've requested before, and I think you're generally sympathetic to this idea of dividing them out into districts. I'm happy to provide some starting language. I'm not running for a seat on the board. I just want things to be done properly. And the other thing, it has to do with dissolution. I think cessation, as Mr. DeBerry's language states, is an okay first step, but I'm not sure why dissolution can't be the proper way to go. The law doesn't prohibit you from doing it. The law doesn't say you can do it or you can't do it. It's silent. So I think that to protect the homeowners, there ought to be a way to dissolve this if in fact it seems to be not working. Now the other question about dissolution, which is important to consider, is to be dissolved into what? I would be shocked if Snowshoe was under the current ownership and they would accept everything back that they gave up. That would shock me. So you can't dissolve it into nothing. There has to be something to take over for all the things that are done, such as plowing roads and so forth. There has to be something in its place, and that has to be a sound discussion. But I would prefer dissolution rather than cessation. I think the homeowners are more protected that way. So with those comments in mind, that's what my position is.
Mike, on multiple properties and various names, I didn't read every response that you and Barry had, but you were working on pretty hard today. And I did see where you had your initial number reduced. I think you had a number of specific cases or names you were still concerned about.
Well, the problem was that if you look at the list of unique owners, it's alphabetized sometimes by last name and sometimes by first name. So if I were looking for, let's say, my name, Mike Pancione, if you were looking for Pancione, Michael, you might find it. But if I was listed as Michael, Pancione, you wouldn't find it because you're looking at Michael.
It's worse than that, actually.
It's very tough. And in our exchanges, which were probably 600 or 700 in the last 12 hours. And by the way, I'm very happy and grateful for Mr. DeBerry entertaining my questions, and he's been very forthcoming with that and very open and accessible. If you look through the list, it's very tough to find these missing links. And he dispelled my confusion, showed me where the problems were, and I did verify. So a lot of my issues disappeared. But there were 5 or 6 people who were not notified after the 18th of March when the petition was submitted.
Who could have been notified?
Could have been notified. And there might have been a few more. I didn't get through all the records and I didn't have time to do it. But, and I'm not saying they would all vote no. The question is, with 10 votes on the table, or 11 votes, whatever the number is, it's so close that it seems to me that it's relevant to consider those people.
That's a good point, Mike. Mr. Berry, how bad is it?
Well, so the trying to identify, and this was to Mr. Simmons' comment, I think this was the challenge that the auditors were having in identifying unique owners and unique protesters was just the mere fact that when you go through the county records, and it states in the statute, that's who you mail to, that's who you use the county records. There could be DeBerry, Frank, there could be DeBerry Frank, there could be Frank DeBerry, there could be Frank Joseph DeBerry. For different properties, it could be listed differently. And trying to go through and decipher which of those were unique, I think it really gave them the same fits that it gave Mr. Penzione here, because you're trying to find a name and there seems to be no order to it. So what the final number did come about from issues like Mr. Penzione mentioned, where Mr. Forrest had said, I have 3 different ownership structures. One is, if I can remember, I think one is me, one is a trust that I have with one child, and maybe one is a trust that I have with another.
One is a trustee his wife had, and the other is his son, and he's the power of attorney.
So, and those, legitimately, if I own the property by myself, I'm one property owner. But if you and I own a property together, that's a unique owner, right?
And that's another.
And so, and to answer your question, I think I do understand. Were owners notified that they could have multiple protests? The calculation, I think what you'll see in the calculation is that if I own one property and you and I own one together, if I sent in one protest, it was automatically counted as 2 unique protests, because I have the legal authority to represent both entities.
So if there's properties owned by more than one person, do both people of that property have a chance to vote?
No, there's only one vote per.
So how would you separate that? I mean, if
well, we didn't have it. We had no cases where one voted for and one voted against, right? So that wasn't anything that had to be dealt with.
So, am I understanding this right? Because of this confusion, that this would have actually increased the no votes?
Well, what it did was it increased both of the protesters and the total number of owners when they went through and they literally matched every name on the list and had to go to county records and identify a specific unique owner. And I will tell you, after they turned it in to you, I personally went through because, I wanted to make sure that this was a sound count. And I, went through myself and matched all 459 to a unique owner, and then matched all, the 1887 and stripped out. And did it with Ms. Lewis back there. We spent about 8 hours actually combing through and trying to make sure that these numbers were accurate after it had been turned in, and found 0 errors on it.
And in those last days, with the auditor there, the young lady that was doing it, anytime she had a problem, then she sent me into the record room and we pulled the records and checked those out. So that's why we were double checking in regard to that. Making a comment in regard to the election itself. I have never seen an election that was done to encourage defeat. And I say that with all honesty because the thing that I objected to right at the start was, if you're trying to get it through, why do you send a letter out there giving them an opportunity to vote against you? Because more people vote against, and we're in a country really that people vote against. And that was the thing that bothered me about it, was because it looked like you were going to lose from the start. because you sent a letter out and said if you're against it, but it didn't say anything about voting for it if you were for it. And so consequently, you got probably more votes against it that you wouldn't have had you not sent those little letters out.
Yeah,
And so, but generally from top to bottom, it was pretty well run, I thought.
And I appreciate that comment. And the statute requires us, literally to make reasonable efforts to mail such notice at least 60 days in advance, right? To say we did anything other than make reasonable efforts, I mean, that would be, that would be an offensive remark in my opinion. I believe we went over the edge. I believe the commission put some steps in there to take us even further, to do that. And I, again, I said I believe that was the right thing to do. And the 6 homeowners, there were 6 homeowners as of the date the petition was submitted who were not on record as the owner of the property yet in the assessor's office. And we, did not send notice to those 6 owners. We sent to the old owners because that's what the assessor's office had as the owner. And I also want to point out in the statute, immaterial defects in the mailing of such notices shall not affect the validity of such notices. I mean, to say that the fact that the county didn't have the record, we had no way of knowing at the time we'd sent those notices that was the case. And one of those 6 actually did protest. So we know that he actually got, received notice.
That's not bad. If you look at online records, and you can find out the ownership changes at a touch of a key on the computer.
Which you did.
Which I did. And I did not, I spent hours on this in the last 3 or 4 days. There were 202 sales of property from January 1st to June 30th of this year in Pocahontas County. Of course, not all of them were at Snowshoe. I went through about 90 records and found a bunch of errors, which surprised me, which in my dialogue with Mr. Berry, most of those went away because of my interpretation of the data and the difficulty of looking at the owner list properly. So through the 90 records, I found 4, maybe 5 owners that were new after the 18th of March, who apparently did not.
They were before the year.
Before. Anyway, they notified.
Sorry, it wasn't 6, it was 5, and 1 had sent a protest, so there's a net effect.
And the truth of the matter is, it's not a big number out of 1,877. I mean, it's a very small percentage. But we're talking about a thin margin of the vote.
Speaking about the margin, the question is whether it's 10 or 11 votes difference. I did define it rounding. The law says 25%, and if you have 460, you can't have a fractional vote. If you have 469 votes of 1877, you have 24.98%. That's not 25%. You need 470 votes to cross that, and that happens to be 25.04%. But so it's 11 votes. You have to cross. You have to get 25.
10 or 11.
With that being said, are we talking about at most 4 votes? That can't. If it were 100% against, that can't make a difference.
Well,
it just depends on, as I said before, it depends on were the owners of multiple properties notified, and Mr. Berry said yes. So they're in the count. So we're talking about, of the 90 records that I went through, I unearthed 4 now that have not been notified, but they're not necessarily voting no. They might vote yes, and they'll be in favor. So it's not a big number. My question was there a process to reach these people? And if there was, then fine. Fine.
Well, I got one question that probably should have asked this a while back, but the email you give us, I assume was addresses and phone numbers and names of property owners on Snowshoe. It was real thick and heavy.
Yeah, correct.
A couple thousand names in the property.
Correct.
Now, was that physical people? Because I looked through that a lot today, comparing it with people that was calling me just to see if they was in there or not. But is that property owners or is that properties?
That was properties to be included within the district, and the
So-
owner of each one of those properties was
So
listed.
if 4 people had one property, would all 4 of their names be in that list, or just one of their names?
The legal entity that owns the property would be on that list.
If you want to run.
So if the 4 of us had a
So
partnership.
basically, them names you give us is how the property was titled.
Yeah, that's
Okay.
exactly it, which is exactly what the statute calls for.
Okay, so if there were 4 people on the same property and 3 of them's name was not on the property,
Right.
then you would not see anybody.
And just, I did some quick math, and I do have that it was 6 unique owners that were not in the mailing, 1 filed a protest. So if you say you have a net of 5, take 1877 minus 5, you get 1872. You now have a 468 threshold, we were at 459. So
That's it.